I should record it for you. Okay, so I'm recording the lecture for you and I will share it. I'll give it to Vishal and Vishal can email you all. Alright. Now we are going to read these questions. As I've mentioned you before, that we should first select the question wisely and then we're going to discuss. The first question is, the restrictions imposed by the courts regarding the use of exemption clauses because of judicial sympathy for the weaker party. Describe the common law rules regarding incorporation and interpretation of exemption clauses. Assess the validity of the statement above. Now, the second question is, compensation for financial loss resulting from breach of contract is more likely than for disappointment or emotional distress. Describe the purposes of damages as a remedy for breach of contract. Assess the fairness of the distinction drawn between the pecuniary and non-pecuniary loss. That's the third question. When the courts develop a new set of principles, there is often doubt about how far these principles extend. Describe the doctrine of promissory estoppel. Assess the validity of the statement above in relation to this doctrine. Now, I would really like to ask you people one by one. I'll do the poll calling so that I can know which people are listening to me and which are not. So, also, I really want to see how you people will select your question in the paper. So yes, Roma, can you please tell us that when you're going to attempt the paper, let's suppose you're attempting this in the CIE, which question are you going to select and why?
Me?
Yes.
I'd attempt this second one probably.
Yes, and why?
Because I think I just know it the best and the structure is easier.
Yes, that is, thank you, Roma. That is a really good question choice. And I'm very happy to see that you did not choose question one specially. And the third question, although the third one is easier also, but we have to see the easiest one and avail the proper opportunity of this choice. And also because this is a really easy and easy to handle, not only to give away all the knowledge but also to structure. So yes, Aisha Imran, can you please tell which question are you going to select in the CIE if this paper was your exam?
I would select question number 2.
Really good. All right, Iman, can you please state your choice?
I think what everyone selected is fine as well.
All right. Okay, so anyone else who would like to select any other question other than question number 2? I mean, it's totally fine if you have adequate knowledge about it and you can structure it and handle it well, then there's absolutely no issue. So I guess everyone seems to be agreeing on question number 2. So let's discuss question number 2 first. All right, so I don't know, is anyone speaking?
Yeah. Would
Fatma,
question 3 be easy to answer?
Yeah, now I can hear you a bit.
So would question 3 be easier to attempt because it's only asking you like one thing and there's a lot of like stuff that you can write for that. Wouldn't that be a better option?
I absolutely agree with you, and I am very happy that nobody selected question number 1 because that was a little tricky question because you had to explain all the common law rules and interpretation, and you had to assess the validity. And when you are asked to assess the validity, you have to have a strong analysis. And when people do not get the strong analysis, you don't get a higher band. All right. And question number 3, I totally agree with you. It is an easy to handle, but it depends on the individual choices and what you people really know better, and that is absolutely fine if you want to answer question number 3 or question number 2. Okay, so I don't know how many of you know the question pattern and answer pattern, like how to write, but please take a note. I'm going to tell you how you're going to get a distinction or an A star and what is going to distinguish between you and an ordinary casual student while you're writing your answer. So first of all, let's discuss question number 2. When you're writing about question number 2, you have to give a small trailer of your question, the answer you're going to write. And that is going to be your introduction. And you're not going to just start writing like compensation for loss resulting in breach, like that. You're not going to start as it is. You're just going to give a trailer to the examiner. And you're going to write it as, this question is about the breach of the contract and the losses that result from this breach. All right, and then this is how you're telling the examiner that you know that which question is this and it has come on and come up from which chapter. So now the examiner knows that all right, this person has distinguished that which chapter that is given in the question. Secondly, you're going to write once you give a little mind map of what you're going to write in the answer further. You're going to say that the following answer will start with the introduction and definition of the breach of contract. It is also going to discuss the disappointment or emotional distress, which is one of the losses of the breaches of the contract. And then you're going to write that this answer or this argument will further be evaluating upon the damages as a remedy of the breach of the contract. And in the end, the debate will end with a final conclusion assessing the fairness of the distinction drawn between pecuniary and non-pecuniary losses, and not only the fairness but also the advantages and disadvantages, or you can write strength and weaknesses. That is how in these 4 lines you're going to make the examiner extremely happy about it. Even if you have a lack of time and you are not able to complete your answer, the examiner mostly he's just going to know that at least the person knew that what he would write. Here is the mark scheme, and then let's see how mark scheme has told us to write about it. So they're saying the candidates should then develop their response by outlining the main ways pecuniary losses and are measured following an actionable breach of the contract and cite relevant cases. We all know that we have to cite these relevant cases. Why? Because when we're going to cite these cases are going to be the evidences or the support of our argument. All right. Now, next we're going to see that how the examiner wants us to start. This is an answer outline, but let's see what are the main things. So they are saying they have stated loss of expectations. See how I told you that you have to first explain what you are going to write and the main principles. You're going to underline them in the question, like compensation for financial losses resulting from a breach of contract. Another highlight is more likely than, which means they're saying that financial loss ज़्यादा होता है, disappointment or emotional distress कम chances होते हैं उसके होने के. That is what you're going to discuss. You're going to have an excellent, strong analysis and an excellent supportive debate with the relevant case laws. Now for disappointment and emotion. Here is the mark scheme, and then let's see how mark scheme has told us to write about it. So they're saying the candidates should then develop their response by outlining the main ways pecuniary losses and are measured following an actionable breach of the contract and cite relevant cases. We all know that we have to cite these relevant cases. Why? Because when we're going to cite these cases are going to be the evidences or the support of our argument. All right. Now, next we're going to see that how the examiner wants us to start. This is an answer outline, but let's see what are the main things. So they are saying they have stated loss of expectations. See how I told you that you have to first explain what you are going to write and the main principles. You're going to underline them in the question, like compensation for financial losses resulting from a breach of contract. Another highlight is more likely than, which means they're saying that financial loss ज़्यादा होता है, disappointment or emotional distress कम chances होते हैं उसके होने के. That is what you're going to discuss. You're going to have an excellent, strong analysis and an excellent supportive debate with the relevant case laws.